Let's have a look at Light Tajiri Bey, Pauline Ritchie, and the property she tried to take over on First Avenue.
With regard to the building that we have proclaimed down the street, we recently put another lien on the building because we had more information this time around. And he sent a text and said, you say 3 days is enough notice when you give a command because they've already been notified. So when we say things, he will come back and challenge what we said based on what we're doing. He said, you say 3 days is enough notice when you give a command because they've already been notified. How come the property on First Avenue is on its second 90? That means that he's able to look in the system and see that there's another lien that's been put on it, and lien stays in place for 90 days if it's not perfected by then. Now, we know how to perfect the lien. We're going to perfect it because we have everything we need to perfect our liens now. We needed to have gold-backed currency to perfect the liens because they're gold instruments. But somehow he was able to look in the system somewhere and see that there's a 90-day lien on that building. And I've not seen what he looked at, but he knew. And I didn't tell anybody that I did another lien on that building. But I did. Another one because I had more information. So somehow he can look in the system and see. But we know we keep our own government records, so we know that our liens work. And this is the same one that was saying, your liens don't work, your liens don't work. Okay, so.
And then what?
Everything that we did with regard to that building, we pulled the real estate piece apart. We put on the public record title, lien, court action. Then we made sure that we didn't have any corporate contracts with anyone at all.
That's because you didn't own it.
And then when we were tested, we stood on our square. So everyone knows who we all are, all men.
You were in jail.
And so now they're able to look, and the subject system is reflecting what it should with regard to the documents and things that we do. And that's the place we want it to be. So what do we do from here? Where do we go from here? We keep pulling each piece apart.
What?
And then keep working to provide for our own government services. What are government services? Government services is not policy enforcers, but police, fire, and that's why we're going into the inspection part of the building.
You're going down to what?
We're going to go down to the building and do an inspection. 2 types of inspections. One is the fire inspection, and the other is just a regular structural inspection.
You do realize you have 3 $5,000 warrants on you, right?
So I'm going to go ahead and call the City versus Pauline Ritchie, 1A250-2975, 7Z120-1571, 7Z714492. Is Miss Ritchie present? If she's not present in court, is she present online? Okay, so today I'm going to consider whether to issue a warrant.
I'm here on behalf of Pauline Ritchie.
And who is speaking?
This is King Abdul Mumin.
Okay, you got to be on video. You got to be on video, sir.
Oh, 1 second, sir. I'm trying to get this situated. I took it off so I wouldn't be a distraction.
No problem. We've had a big calendar this morning. I appreciate your patience.
Yes. Okay. Here I am.
Okay.
All righty.
Okay. So the question today, and the sole question today, is whether I should resummon Miss Ritchie to appear, or whether I should issue a warrant for arrest. So I've already talked to you, sir, about practicing law, and so I'm going to tell you again that it is not legal. I'm not accusing you of anything. I'm just telling you it's not legal, and then you can go from there. But the city's position on whether a warrant should issue or whether I should resummon.
For the record, I'm a Shepherd County for the city. Your Honor, the city is requesting a warrant at this point in time. There has been a number of hearings where Ms. Ritchie has failed to appear. We have resummoned, I believe, even as early as the March 16th date. She has not been present. She's been given notice to appear. And clearly, even though Mr. King Abdul Mumin states that he is her attorney, he at least knows her, has probably spoken to her about this hearing and given her notice in some other way, shape, or form. But nonetheless, she has been given legal notice to be present on a number of occasions. She is not. The city is requesting a warrant on each of these cases.
Is this a necessary hearing under Galinas?
I do believe it's a necessary hearing, Your Honor. One, we do not have a barred attorney who can represent Ms. Ritchie and state that they have had a conversation with her regarding whether or not she desires to continue this case, resolve this case. Additionally, one of these matters is scheduled for arraignment, which certainly is a necessary hearing. The other two, their posture are in a pretrial status after a competency evaluation was completed. And on the last date, we did, Your Honor, did make a finding with no objection from the city that the defendant is competent at the time. So I do believe that these are all necessary hearings.
The arraignment doesn't have to go through that test because it's already necessary by court rule. The
yes,
pretrials are well. Any other comments from anybody?
Yes, I'm still here commenting. You have a new amended notice of appearance filed, and it's stating you as a third-party defendant, Ms. Emily Shepherd, whatever her last name is, the prosecuting attorney that's talking at this time. She's been served. And as well as Ms. Karama Hawkins for Hawkins and Crawford. Also, Ms. Rebecca C. Robertson, she's the other court officer. And Mr. Weaver, I see you smiling. You have something to say?
Mr. Weaver? Mr. Weaver.
You have something to say?
Mr. King Abdul, just address the court, please.
Yeah, I'm addressing everything here.
Just address the court.
I'm addressing everything here, sir. I am the court. You keep expressing yourself as being the court. We're here. We have a conflict of interest here. Okay? And the document, do you have the notice of appearance that I filed?
Okay. Sir, at the last hearing, I made it clear that I have no jurisdiction to address those issues that you want to raise.
Sir, we're not talking about the last hearing.
No, just a minute.
Okay.
The question today is, should I issue a warrant or not issue a warrant for Ms. Ritchie? That's the question. That's the sole question. I don't need to hear anything else.
Well, you will hear other things, sir.
I'm going to hear about whether the warrant needs to be issued or not.
You're not going to hear that because you're dealing with my court. And the issues that you have presenting before our court is that you're using a human trafficking program, and that's not going to work today. You're using these statutes and codes. You're trying to force someone to come to a phony court. You won't participate in providing your oath of office and your official bond, but you don't want to talk about nothing else. You want to put me in a box or everybody else in a box because you think you have a superior office or something like that. We went through the last situation where you said you weren't bound. So therefore, a fair hearing needs to be taking place and everything needs to be heard properly. You can't hear it because you're part of the problem.
Okay.
So
should I issue a warrant or not issue a warrant? No, you can't. Don't issue a warrant until we have it heard by Joe Biden and my people, the Moors, because Pauline Denise Ritchie Moore is a noble, and you never gave her proper counsel for her defense, so she was at a disadvantage from the very beginning. And so whenever you deny someone access to their court, there's a problem. Okay, again, I'm still talking, sir. Let me finish because my elaboration on what I have to say is more detailed than what you might normally hear. Okay, when you're taking someone's liberty
Okay? You just don't take somebody's liberty because you say you can do it. Now, I stress the value of you providing your official bond. You seem to think that you don't have to step up to the plate. It's like any other business that you might charge with. Did you have your bond for your license or for your business? It's the same thing with you. You're no different. So I'm demanding the same thing from you. Before you can even proceed, sir, you and Emily and Mr. Matt and the rest of you attorneys, you have to still come up with your bonds. I don't know what you think you're doing where you think you're going to bypass our birthrights as nobles to this land and owners of this land. And you're not the owner. And you know you're a citizen, but yet still you want to sit there and pretend to be a Morgan. What is your problem?
Yeah, I just want to know whether I should issue a warrant or not. Sir, and just a moment. Miss Ritchie waived counsel in the two cases that are set for pretrial. She voluntarily chose not to go with a lawyer, and at the last hearing, Miss Hawkins was fired, as I recall, from the arraignment. She withdrew from the arraignment. We haven't had a chance to go over a waiver of counsel or whether she should have appointed counsel in the arraignment because she hasn't appeared. And so therefore, in terms of denying her counsel, that's patently false, sir. So if you're going to come into my court, you're not going to say things that are untrue. Okay? And next is the sole issue today is whether a warrant should issue or not. Is there anything further on that particular issue?
I explained to you that the warrant that you're trying to issue should not be issued based upon the fact that you haven't provided your oath and your official bond.
What authority do you have for that, sir?
No, what authority do you have not to give anybody the proof that you are who you say you are when you're doing business? In order to do business, sir, you need to have the proper documentation. And we're testing your ability to sit there, as I told you before. You're pretending to be. See, you're playing games. You're prepared for this argument. Last time you claimed that I was practicing law, and you found out that you were bound to the Moors. Now you act like you're still not bound to the Moors. So what I'm explaining to you, I am counsel in this particular matter, okay? And I am a private U.S. Attorney General. I've been conducting a federal criminal investigation against this whole government for human trafficking Moorish Americans and killing them for sport and others. Your program that you have, like you said last time, you didn't know this law that I'm talking about. It's very new to you. And so when you're talking about taking Pauline Ritchie Moore's liberty, you're talking about treaty law. You're not talking about something where you can just say, well, I'm going to just bypass this treaty, and like I told you before, and use these statutes and codes. I'm not going to talk. We can't talk about this.
I have no jurisdiction to decide treaties at the U.S. District Court.
Well, let's move it to the district court then. That's
you
where
can try.
No, we shall remove it now.
Wait, sir. I'm going to make a decision, and I'm just telling you right now, if the decision's not liked, then there can be an extraordinary appeal with writ of habeas corpus, or actually other petitions that can be brought in a higher court to.
No, sir. You're premeditating everything.
Just a moment. I'm going to make a decision. It appears that we have tried to summon Miss Ritchie to numerous hearings. She's not appeared. We only have the address on Southwest 314th Place with the department licensing and with in the court system. The people have appeared on her behalf. She's because of that, she does have notice of the hearings. She knows when the hearings are, so she's asked folks to appear for her on her behalf.
Have you served her? You have proof of service on the file, sir?
The service is by mail, which is allowed. I'm going to issue warrants, and the warrants are going to be in the amount of $5,000 a piece. And there is adequate notice of the hearings, as evidenced by numerous folks that have appeared on her behalf today, or in support of her. Okay, and on the Ritchie matter, the hearing's concluded.
conflict of interest, sir. I don't know what you think you're doing. You're really a terrible judge. You're not a judge. So I don't get what you think you're doing. Now I ask you to provide your bond. You think this is a game? Do you have it?
We need that information.
My bond to you, or if I had to provide my bond to you, I would have. If you cite me authority that says I'm supposed to give you my bond, I'll look at it as
Sir, I don't cite case law.
I have an oath of office that's filed with, and you can get the public disclosure through the county auditor, and there are certificates of election that authenticates my authority. Article 4 of the Constitution defines the legislature's ability to create courts of limited jurisdiction, which is created in the RCW 3.50.
You start today.
Is operated through that. I know you don't agree with me, sir.
Constitution is void, sir.
Is there anything further?
Yes, I keep asking you for your proper information. And why is it that you
I've given it to you.
Pauline, no, you haven't given anything to me other than this scallywag and carpetbagger con game. That's all you have, sir.
Okay.
It's all about ignoring the
At
facts.
this point in time, sir, I don't think anything else today is productive. And so
You can
I
never be
think,
productive.
right, and I think I got to move on to the other cases that I have today. So you have a great
You
day.
did a fine job bypassing our birthrights. We will see you later.
Okay.
Islam, peace and love to you, crook. Tell you
Yes, sir.
you crooks, we got you.
Thank you, sir. You have a great one.
No, we ain't gonna have a great nothing. They'll see you. You know you're a defendant, third-party defendant, sir. What do you think you're doing? See, you're a criminal. This is what I explained to you. You cannot bypass our birthrights. And now you want to just dismiss everything. You don't have the authority, sir. If you said you didn't have jurisdiction, you're full of it. Provide me with your bond. Anybody has anything to say about his bond, Morris?
Okay, I think we're done.
No,
Thank you.
you're not done. Provide me with your bond, sir. Where is
I've muted you. Okay, we're going to move on to the other hearings.
And now, whatever happened to King Abdul Mumin L, a.k.a. Joseph Pigott?
I'm Empress Sophia L. Bey, and today I have King Abdul Mumin L. I'm sorry, I apologize for that. And today we are going to go over a case and charges that have been erroneously filed on King after we had a hearing on March the 30th with this fake judge, David Allen Larson. And I wanted to bring King Abdul on so that we can start where we left off the last time we were going live. So welcome to my channel, King Abdul.
Well, thank you very much, Empress Sophia.
Oh, you're welcome.
Yes.
So what I want to do is talk about the hearing that we were involved in on Zoom because it was our courts. And I'm also a witness because I was there with you. Is that correct?
Correct.
Okay. And I remember you educating this judge, and he would listen. And you started educating him on the law, the supreme law of the land. Is that correct?
Correct.
Okay. And so while we were in this hearing, can you further expand on your thoughts about what this judge has done? And I want to talk about what has transpired since that hearing of these new fake charges that have been brought against you.
Yeah, so Joseph Stanley Pigott, King Abdul Mumin, has charges. Pauline Ritchie, 3 $5,000 warrants.